Okay, good morning, and here we are for another construction question time with Brandon Silver. Good morning, Brandon.
Morning, Julie. How are you? You okay?
Good, thank you very much. Right, we're looking forward to hearing the answer to the following question. So, Brandon, what is the construction adjudication process, please?
So yeah, thank you, Julie, for that question. I would say probably this is the most important vlog I've done so far, and something that definitely should be listened to, because I think the adjudication process is the most common approach to resolving disputes in construction. So obviously in previous weeks, I've spoken about delays, liquidated damages. If there are disputes between the parties, then this is commonly resolved by adjudication. So today I'm going to talk about the adjudication process, and indeed what we deal with mostly for our clients is adjudication. So this is something very useful to listen to. So firstly, what actually is adjudication? It's a process to resolve disputes, often construction disputes. And importantly, the main difference is that you do not need court intervention. If there's court intervention, then that's called litigation. And the main advantage for adjudication is that it's not so costly as litigation, and also it doesn't take as long. For court proceedings, it can take a lot longer, whereas I will discuss in a bit more detail later. The time constraints for adjudication are a lot less, so it can be a decision made a lot quicker. So I'm going to talk about two separate sections. I'm firstly going to talk about the scope of adjudication, and then I'm going to talk in a bit more detail about the actual adjudication process, and go through 7 different steps, which I think is quite useful. So firstly, talking about the scope, who can actually partake in an adjudication? Well, as per the Housing Grants, Construction and Regeneration Act, which is the main act for construction, any party to a construction contract can refer a matter to adjudication. So the question that follows, well, what is a construction contract? Now, the legislation gives a rather broad definition, which explains why most disputes are referred and can be referred to adjudication. Indeed, there is no requirement that the contract has to be in writing to be a construction contract. It can be oral. And also, even if the parties seek to contract out of the adjudication process and say, for example, in the contract, I do not wish adjudication to be the process if there's a dispute between the parties, that is not permitted under the Act. And also, even if the contract does not include any provisions for adjudication, then they would be implied into the contract by the Act. So this kind of explains why adjudication is the main process and what we deal with most commonly. So typically, most parties can partake in an adjudication. Second question I'm going to talk about under scope of adjudication is, well, what kind of disputes can I refer to adjudication for them to be resolved? Well, on behalf of our clients, we have been dealing with a lot of different matters that have been referred to adjudication. Just to give you a flavour, we've dealt with delay and disruption claims, extension of time claims, disputes relating to final accounts, disputes relating to loss and expense, disputes as to non-payment of sums that are considered to be notified sums, also claims into relation to termination issues, whether the termination has been unlawful or not, has it been unreasonable or vexatious, and also any other breach of contract claims, maybe, for example, defects, anything like that. So a lot of different disputes can be referred to adjudication, and we have acted both as representative for the referring party and the responding party. So in both these claims, so we're very well experienced in these matters. So that's the scope of adjudication. I'm now going to talk about the actual process of adjudication. And as I mentioned at the beginning, I'm going to run through 7 different steps, which will hopefully explain the process in a little bit more detail and understand what we can do on your behalf. So the first thing is, for an adjudication, for you to refer a matter to adjudication, there must be a dispute. If there's not a dispute, then of course, it makes sense, you cannot refer the matter to adjudication. So for there to be a dispute, there obviously has to be a disagreement between the parties, and one party, i.e. the referring party, is seeking redress. So by way of example, let's say there's a dispute between the parties where one party is claiming liquidated damages, the other party is refusing, saying they're not entitled, the relief, the redress sought, would be a payment of, say, I don't know, £3,000 a week for 10 weeks liquidated damages, and that would be what they sought from the adjudicator. So that would clearly satisfy the test and would be a dispute. So that's point number one. Point number two is that the claim must be crystallized. So what does crystallized mean? Well, it means that the claim must have been clearly presented to the other side in writing before the formal adjudication process has been commenced. This is very similar to litigation, where before you issue a claim and submit it to the court, you would have a letter before action, which you send to the other side, which is called an LBA. This is basically notifying the other side of your claim beforehand. Now, the reason it is very important to ensure that the claim has crystallized before you start commencing the adjudication process is that if it's the case that the claim has not been crystallized, and yet you bring the case to adjudication and a decision is made and the party seeks to enforce it, the courts will not enforce it if the dispute has not been crystallized. So it's very important. And obviously this is something that we would ensure and before actually commencing adjudication, we would issue the relevant letters to the other side. So to ensure that the process is all met. So let's say now, so this is now point number 3 I'm going on to of 7. Let's say that the claim has now crystallized. What's next? Well, what we would do on your behalf, and this is in the event that we are acting for you as the referring party, we would draft, prepare, and serve the notice of adjudication. So what is this? This is a document which is sent to the other side, and it notifies them of our client's intention to refer the matter to adjudication. Now, this document gives a brief summary of the dispute, outlines the parties, the contract terms, the relevant contract terms, and also the redress sought. And this clearly defines the scope of the adjudication. So it's very important, the notice, to clearly outline what the dispute is, because you can't then later add stuff in the referral, because then the adjudicator will not have jurisdiction to decide those matters. So that's something that we would draft on your behalf and ensure again that it meets all the relevant criteria. Once the notice has been served, you then need to make an application for the appointment of adjudicator. This is point number 4, by the way. Now, when you're making an application for the appointment of adjudicator, you need to refer to the contract terms to see who is the relevant nominating body. There are a number of bodies who you can apply for the appointment of an adjudicator. So let's say, for example, the contract says appointment by the RICS, the Royal Institute of Chartered Surveyors, then of course we would apply to them on your behalf. So we would check the contract and ensure that the relevant body is applied to. Please note that sometimes the contract may be silent, and then there's more flexibility, and we can advise which one we think is the best. So, and also just to mention in terms of timescales, the adjudicator must be appointed within 7 days of service of the notice of adjudication. So that's the document I just briefly mentioned in point number 4. So point number 5, once the adjudicator has been appointed, you then need to serve, and this is again, if you're acting as the referring party, you need to serve the referral notice. And this again would be something that we would draft and prepare on your behalf. And the referral notice is kind of more of a more sophisticated, more detailed document than the notice of adjudication, outlining in more detail the dispute, the redress sought, and the contract terms we're relying on. It would also include all the appendixes or exhibits, so for example, witness statements and any supporting documentation as to costs or anything like that, or expert reports. Again, in a similar fashion to the appointment of the adjudicator, the referral notice needs to be served within 7 days of the notice of adjudication. So again, that's just on timings. So point number 6, and this links well with what I mentioned at the beginning, with litigation being a lot longer in time. I'm now going to just briefly summarize the timings as to an adjudication.
Okay, welcome back, Brandon.
Apologies for that. I just had a call, so it stopped the recording. But let me just carry on from where I was at. So I was then talking about the timings for an adjudication. So obviously you have the referral notice. Then what happens is the parties will exchange a number of submissions, and it depends very much how many submissions are made. But so the first submission is a referral, the next one would be a response, third one's a reply, and so on and so forth. Now, the typical time is that an adjudicator must issue their decision within 28 days of service of the referral. That's the typical time. The referring party can agree an extension to this to 42 days after referral notice, and indeed there can be a further extension agreed between both of the parties. But as you can, and obviously this will depend on the complexity of the matter at hand and how many submissions are made on behalf of the parties. But obviously you can see from this, it's a much quicker process than litigation would be. So this is one of the main advantages for adjudication. So that was point 6. The final point is just talking about the actual decision made from the adjudicator. So this is described as being temporarily binding. Now what that means is that it's binding on the parties until the underlying dispute is litigated, arbitrated, or settled. Now what you can do to actually enforce the adjudicator's decision is that you apply to the court for summary judgment enforcing the adjudicator's decision. The court would then, if it deems it should be the case, would enforce the decision, and therefore it's then binding on the parties. So that's the 7 points as to the process. And obviously I mentioned about the scope at the beginning. So if you have any questions in relation to this, if you believe that you have a claim, a dispute between the parties and would like to refer it to adjudication, or alternatively, you've already, as a party, been served a notice on the other side and you would like some advice or for us to represent you, then please do not hesitate to contact me. As I mentioned, we have experience in a lot of different matters and we would be happy to assist. My email is brandonsilver@silverllp.com. Thank you for listening.
Okay, thank you, Brandon. Break just made it even more interesting.
Yeah, apologies for that, but thank you all for listening.
Problem. We will see you soon for another construction question, which you will answer in your same able way. We look forward to
Thank you, Julie. Thanks.
Take care.
Bye.